Good afternoon, everyone. Thank you for joining. I'm going to wait just a minute for others to sign on, and then we'll go ahead and get started. All right, good afternoon, everyone. I'm going to go ahead and get started. We have a lot of ground to cover today. My name is Stephanie Baez, and I am pro bono counsel for the ABA Commission on Immigration. And today I'm going to be talking to you about temporary protected status for non-citizens in removal proceedings. I know that a fair amount of people who are joining this training are working on cases that are involving respondents who are in dedicated docket cases, family group dedicated docket cases. So we'll be touching on that specifically as well today. Let me make sure my slides are working here. And as you can see in the chat function, we're asking that everyone uses the Q&A box, not the chat, if you've got questions today. Please use the Q&A box, and those questions will be moderated, and probably we'll do Q&A at the end of today's session, but we might jump in with some questions throughout as well. So please feel free to ask questions anytime that they occur to you, but you do so in the Q&A box. All right. For an overview of today's training, we're going to start with an overview of the TPS process. But really today's training is focusing on some issues and challenges with TPS and what it's like when you're seeking TPS when you have a client who's in removal proceedings. So our overview of the TPS process is going to be high level, and we're going to move fairly quickly through that. If you're someone who needs a more in-depth, step-by-step training on the TPS process and how to fill out TPS forms, you can shoot me an email after, and I can refer you to some excellent trainings that have been done by wonderful organizations that have really put together those trainings, and I can refer you to them. So definitely feel free to reach out if you need that information, because we are going to speed through it fairly quickly today so that we can really focus on the TPS in removal proceedings issue. But to start, an overview of the TPS process. What is TPS? TPS is a short-term benefit for non-citizens who can't return to their home country safely due to some temporary conditions that are preventing them from returning. So common conditions would include civil war, an environmental disaster like a hurricane or an earthquake, or other temporary extraordinary measures that might prevent them from being able to return. And for a country to be designated a TPS country, the Secretary of DHS issues that designation after consultation with the Secretary of State. So the process for seeking TPS is that first, the Secretary of DHS designates a certain country, and USCIS issues a notice in the Federal Register that has the registration process for TPS. Non-citizens submit their application. They can apply for TPS and also for employment authorization as part of their application. And TPS is typically granted for about an 18-month period. It's set for an 18-month period. And prior to the expiration of that initial TPS designation, DHS can decide whether they're going to extend the TPS period, whether they're going to redesignate a different period where additional non-citizens can apply, or whether they're going to terminate TPS and those benefits will expire. So it's something that's reviewed and renewed or terminated as DHS sees fit. The eligibility requirements, they're the same for every country in terms of the broad strokes, but I'm going to focus specifically on the Haiti requirements, since Haiti was recently designated as a TPS country. And a lot of the cases that we're seeing right now, specifically with the family group dedicated dockets that I'm going to touch on, involve Haitian families. So the eligibility requirements for a Haitian national would be first to prove that they are a Haitian national, and to show that they have had continuous residence in the United States since July 29th of 2021, and continuous physical presence since August 3rd, 2021. The difference between those two, that physical presence refers to whether they've physically actually been here, not leaving the country on any vacations or any visits outside the country, but physically in the United States since that August 3rd date. Continuous residence refers to whether they have established residence here and have lived here since at least July 29th of 2021. The benefits of TPS are that a recipient of TPS is not subject to immigration detention or removal. They are eligible for work authorization, which EAD you'll see referred to throughout. It's an employment authorization document. And they're eligible to apply for travel authorization, which is also referred to as advance parole. But the limitations of TPS is that it's a short-term protection, short duration, generally between 6 to 18 months of protection, unless it's extended for a longer period of time. There's no pathway to residency through or to citizenship through TPS. And there's no ability to bring family members over with TPS. So you can't bring family from Haiti to join. Additionally, there's no derivative status, meaning that someone's spouse or children must apply individually. It's an individual benefit. There are some bars to seeking TPS. If you have a client who has a conviction of a felony or 2 or more misdemeanors, they will be barred from seeking TPS. There's also some factors of inadmissibility pursuant to INA section 212A. And these inadmissibility factors, some of them are considered to be waivable, meaning that your client could file a form I-601 waiver and potentially still seek TPS, even though they have one of these inadmissible factors that apply to them. There are also some factors that are non-waivable, meaning if these apply, they are not going to be eligible for TPS. So some of the waivable factors include prostitution, certain controlled substance violations, drug abuse or addiction, certain fraud violations, and certain smuggling violations. But non-waivable would include crimes involving moral turpitude, if there's multiple criminal convictions, drug trafficking, security threats or terrorism threats, or participants in Nazi genocide. Those are things that are non-waivable, and your client will not be eligible for TPS in those circumstances. Other bars to seeking TPS include the bars that are the mandatory bars to asylum. So the statute is cited here, and you can review what the bars to asylum are, and those same things apply to TPS. The one that I want to highlight here is if someone's been firmly resettled in another country prior to arriving in the United States. That is a bar to asylum, and it also can be a bar to TPS, and we're going to spend a good portion of today's conversation talking about that potential bar and how to get around it. Also, if you have a client who fails to meet the continuous presence and residence requirements, if they weren't here on the dates of designation that are required, then that's going to be a bar to seeking TPS. Or if they fail to meet the registration requirements and don't apply for TPS, then that will also be a bar. The TPS application itself includes the forms that are listed on this slide. So we've got the application, there's an application for work authorization, a waiver of inadmissibility if applicable, if your client has one of those inadmissible factors that apply to them, potentially a fee waiver if your client's not able to afford the filing fees for TPS, a cover letter with the proof of eligibility that make your client eligible for TPS, and I'm going to get more into that in just 1 minute, 2 passport style photos, and potentially an application for a travel document. Again, for those who might have missed it at the beginning, today's training, I'm not going to go through these forms step by step and tell you how to fill them out or how to apply for TPS. We're going to talk more about what the TPS application, how that impacts your case in removal proceedings. But if you need that instruction, please feel free to reach out to me. I'll give you my email address at the end of today's presentation, and I can refer you to some great trainings that do a step-by-step walkthrough of how to submit a TPS application. But for today, a few practice pointers that I want you to be aware of. First, there's a recommendation to have your client apply for employment authorization, even if there's no intention of that person working. So if your client is elderly and is retired and doesn't plan on working, or if your client is a young child, because remember, everyone needs to file an individual application for TPS. So there's no derivatives for children on their parents' application. A child, a 5-year-old, for example, has to file his own application. It's still recommended that that 5-year-old seeks employment authorization because he can get a social security number. And that's just an added benefit through that, even if there's no intention of actually working. And filing fees, I'm going to touch on the actual fees in the next slide. But one thing to note is that the processing times for the TPS application can be delayed with a fee waiver. And ultimately, the fee waiver request could be denied. So it's a consideration to really have that conversation with your client and see if there's any possible way for them to pay the fees that are associated with TPS. Because if they can pay the fees, if they can borrow the money, if they can figure out a way to do it, it will help their application move faster. And that can be an especially important consideration if your client is in removal proceedings and need their application to be processed and granted because of implications in their removal case. So definitely have that conversation with your client. I know the fees can be very difficult for a lot of people, but if it's possible for them to pay, there could be some advantages to them so that they can move forward more quickly. Now onto the fees themselves. This slide just has a chart of what the fees are. You can see here that for the filing fee for TPS is $50. And then there's a biometric services fee that is $85. It's not applicable to children younger than 14, but for everyone else, it's $85. And then the employment authorization, that's the I-765. That's really the big expense. $410 for people who are between 14 and 65 years old. So the total cost for someone who's between 14 and 65 is $545. So it's not an insignificant cost, but again, if your client can't afford to pay it, it can help their application move faster. And you'll see that it's free for someone who's younger than 14 or older than 66 to apply for employment authorization. So that's another reason why it's recommended that they go ahead and do it, even if they don't plan to work, because there's no fee associated with it, so they can get that Social Security number without paying the fee. Now, supporting evidence that goes, oh, go ahead. Yes,
I just wanted to ask you one question.
On the call with a question. Mm-hmm.
Is there any way to break that up as potentially maybe if somebody wants to pay for just the TPS application and perhaps seek work authorization and pay that filing fee later? Is that another conversation you could potentially have with your client?
Yes, and that's a great question and a great point. That would be another way to potentially make it more economically feasible for your client. Let me go back to that slide, would be to split the fees up. If they are able to pay for the TPS application and biometric services out of pocket and use the fee waiver for the employment authorization, then it might slow down their employment authorization, which has other consequences that you'll want to talk to them about, whether it's better to spend the money up front and be able to work sooner or, vice versa. But at least for the TPS application itself, that part wouldn't be delayed by the processing of a fee waiver. So that is definitely a possibility if your client's not able to come up with that full amount up front. Now moving on to supporting evidence. These are the documents that need to be attached with your application. So all of the list of forms that I went through that need to be part of the TPS application should have this evidence behind them. We recommend having a cover letter on the front that outlines for USCIS what evidence is being submitted. And one quick practice pointer on that cover letter, make sure you're sending your letter and your application packet to the right address. The USCIS website linked here has a list of different TPS countries and the addresses where their applications should be mailed. The address can change depending on the country that your client is from, the state where your client lives, and the method that you're mailing the application. So whether it's through UPS or FedEx versus through the Postal Service, there's going to be a different place for those applications to be submitted. So make sure you check out the right address. Another practice tip is that any documents, so any of the supporting evidence I'm about to mention, if it's in a foreign language, then the original needs to be submitted along with a certified translation that is accompanying the documents, so that the documents are also submitted in English with a signed certified translation attached. Each applicant also needs to submit 2 passport-sized photographs. And just another reminder that there's no beneficiaries on a TPS application. So each person needs to submit their own individual application with this evidence attached. So the first bucket of evidence is the documentation that shows, again, this is specific to Haiti, all of my examples throughout today's presentation, but it's going to be the bucket of evidence that shows Haitian nationality. So that can be a Haitian passport, a birth certificate, or another national ID document. If your client is stateless, then they need to show that their habitual residence was in Haiti, and that can be done by a sworn affidavit or some secondary evidence showing residence in Haiti. But if there's a Haitian passport or birth certificate or national ID document, that's going to be your strongest evidence for nationality. Now, we also need to show continuous residence in the United States. And remember, that's evidence to show that your client has resided here and has set up the United States as their, their place of residence, their place of home. So documents that can show this are things that have your client's name and date and an address in the United States that establishes that this is where they reside. Employment records, rent receipts or utility bills, school records if their children are attending school in the United States or if they're taking classes, hospital or medical records, attestations by a church or a union or other organization. Those are all examples of helpful evidence. One example of not so helpful evidence would be, for example, grocery receipts, where they might have gone to the grocery store and they have receipts showing all the food that they've purchased. If those receipts don't have your client's name on them, then it's not really helpful evidence because it's not proof that it was specifically your client here in the United States purchasing those groceries. And then your continuous physical presence residence some of it overlaps with the continuous residence evidence, but also you can show if your client entered lawfully, a passport entry stamp showing when they entered into the United States, their I-94 entry record. And then one important thing that I want to note for clients in removal proceedings specifically, you'll have the benefit of having an NTA and potentially having records of master calendar hearings if your client has been in court proceedings. You can use those documents showing that your client has gone to court on the various occasions that they have. If your client signed a retainer agreement with you showing that you entered into a representation, those types of things showing that your client has been here can also be helpful evidence. So you submit your application with all of the required forms, your required evidence, and you mail it off to USCIS to file it, along with either a fee waiver or the money order if your client is able to pay. And generally speaking, it takes about 6 weeks to get receipt notices after filing for TPS. You'll also get a notice for a biometrics appointment. That is a notice that your client needs to go have their fingerprints and photographs taken at a USCIS field office. And then after that, it could be another 3 to 4 months to get a response on the TPS application. These are all approximate times. We all know that there are big delays in immigration processing, but relatively speaking, TPS tends to be processed faster than other types of immigration relief because it's a short-term type of relief. So, it expires if it's only valid for an 18-month period, so there needs to be a little bit more expedited processing, but there's still plenty of delays in the TPS world. All right, now we're going to jump into some common issues and challenges that we see with TPS. And again, a lot of these are specific to the Haitian context is what I'm going to be talking about today, but they can apply to people from all different countries. So one issue that we commonly see is dual nationality. Dual nationality is where someone has citizenship in more than one country. And the dual nationality itself is not a bar to TPS, but you need to be able to prove that your client is actually a citizen of the TPS designated country. So if your client, for example, is a citizen of both Haiti and Chile, that's not necessarily a bar to TPS, but you do need to be able to show and prove that they are a Haitian national. One potential way to do that is through something called the operative nationality test. And this is outlined in the case law that's cited here. But the basic factors that could be considered to show that if someone has 2 citizenships, we're looking at their operative nationality, is to look at what passport they used when they're entering the United States. If they were apprehended by immigration authorities, what citizenship did they allege at that time and did they admit to? And where did they live prior to entering the United States? And so one way to argue that your client is as a Haitian citizen, for example, would be if those factors really support that your client was most recently in Haiti or arrived into the United States on a Haitian passport. That's not always the case with our clients. And sometimes we have examples, for example, a very common occurrence, especially with Haitian clients, is a family that lived in a different country, a third country, before coming to the United States, and have a young child that was born in that third country. So then how to determine whether that applicant, the young child, has citizenship in which country, in both countries, is that person a Haitian national? For that, we can really look to the jus sanguinis and jus soli determination of citizenship. So whether we can look at each country and see whether they have citizenship that's derived from a right of blood or right of soil. I'll give you an example using Haiti specifically. So Haiti is a jus sanguinis state. That means that nationality for Haitians is conferred by the bloodline. So a person could be born in Haiti, on the soil of Haiti, but to non-Haitian parents, and that person is not a Haitian national. But conversely, a person can be born outside of Haiti in a third country to a Haitian parent, and that person is a Haitian national because we're looking at their bloodline. So that's the situation that we're seeing with a lot of Haitian families that are arriving. They might have a young child who was born in Chile, for example, to Haitian parents. And so that child has Chilean citizenship, and we need to also prove for the TPS application that they are Haitian. So how can we do that? The easiest way, in theory, would be to obtain a Haitian ID for that child. If they also happen to have a Haitian passport or other documentation showing that they're a Haitian national, that's great, and that should be submitted with your TPS application. However, that can take a really long time to obtain that if they don't have it already. So another option is to submit your birth certificate for the child, the Chilean birth certificate with a certified translation that names the Haitian parents as the child's parents. And then you will also submit copies of the passport or birth certificates showing that the Haitian parents are Haitian. And along with that, submit an excerpt from the Haitian Constitution, the section that shows that children of Haitian parents are Haitian. And with that evidence together, you can show that this child who was born in Chile to Haitian nationals is a Haitian national under the Haitian Constitution. And that can be a quicker way to show that, even if there's a dual nationality, that your client is a citizen of Haiti if you're not able to obtain a Haitian ID. This chart, I'm including the materials. It was created by the organizations listed at the bottom there, but it's a great visual, and so I wanted to include it. It's very helpful in terms of the common countries that we are seeing a lot of our Haitian clients pass through, and maybe have children who are born in these other countries. And it gives an overview of their citizenship rules and whether they're jus sanguinis or jus soli state countries. Now, another common issue that comes up, especially in the context of Haitian TPS, a complication, is firm resettlement. So firm resettlement is if someone has, prior to arrival in the United States, they received an offer of permanent resident status, citizenship, or some other permanent resettlement, where they could have stayed in a third country before coming to the United States. The question of firm resettlement is particularly common with Haitian nationals who are arriving in the United States right now, because many people lived in a third country such as Brazil or Chile for maybe a couple of years before coming into the United States most recently. One thing to note about firm resettlement is that DHS has the burden of demonstrating firm resettlement. So if you've got a question of whether your client was firmly resettled or not, that shouldn't be something that prevents you from applying for submitting their TPS application. Go ahead and submit that application. And on the application, it will ask, did your client live in, lists the other countries where the client resided prior to coming into the United States. And you fill out that application honestly, but also fill it out succinctly. And you don't need to provide, extra detail or evidence in the initial application, because DHS is the one that really has the burden of raising the question of firm resettlement. After you submit your TPS application, DHS could come back with a request for evidence, and they could present prima facie evidence of an offer of resettlement in another country. And then your applicant, your client, can rebut that evidence by showing that an offer of firm resettlement wasn't made, or they wouldn't qualify for it. But ultimately, if your client is deemed to have been firmly resettled, even that's not a total bar to TPS, because your client has the opportunity to establish that there was an exception to firm resettlement that applies, so that they still are able to qualify for TPS. So let's break that down a little bit further. If there is a designation of firm resettlement, then these two exceptions could apply. One is persecution, or we also call that incident to flight, meaning that your client entered into this third country only as a necessary consequence when they were fleeing from persecution in their home country. And they only stayed in that country long enough to arrange onward travel to the United States. So you could show that they have no significant ties to the country, that they didn't open a bank account, that they weren't enrolled in school there, that if they had employment, it was temporary employment, that they didn't have the ability to stay in the country long term, that was never their intention, and they only had no significant ties. Another exception, and this again is very common for Haitian families that we're now seeing in the US, is a substantial restriction exception. And this exception is that conditions of residence were so substantially and consciously restricted that the family or the client could not, in fact, be deemed resettled. Examples: in a country, if housing is not available because of issues, oftentimes there's extreme racism that's faced. And so Haitian immigrants or other Black immigrants aren't able to find any sort of housing or permanent place to live. They're not able to find employment, either due to racism or general xenophobia. They're not able to enjoy rights and privileges that are ordinarily available to others in that country. They can't obtain property. They're not able to obtain travel documentation or education or those types of benefits. Then there can be an argument made that there's substantial restrictions that mean that they're not able to actually be firmly resettled in those countries. I already went over some of these practice tips on firm resettlement, just to keep in mind that DHS bears the initial burden. So you want to be succinct in your initial application, because if DHS then comes back with a request for evidence, you want to then be able to establish your case and submit evidence, rather than submitting everything up front. And then if they come back for a request for evidence, you don't have other things to present to make your case. And when you're submitting your response to the request for evidence, you can include a declaration from the applicant indicating that it was only their intent to stay in the third country for a short period of time, why they were delayed in getting to the United States, and whether they experienced violence, lack of employment opportunities, wage disparity, other sorts of inability to be firmly resettled in that country. You can also consider including an expert declaration that describes the violence and discrimination against Haitians, if your clients are Haitian or whatever nationality they're from, in that third country. And also submit country condition reports that describe the restrictions on rights that clients from your country face in whatever third country they were in. And one excellent resource is the CGRS resources for Haitians who have stayed in Brazil or Chile, and there's a link here. These are excellent country conditions reports that can help if you've got a Haitian client who's spent significant time in Brazil or Chile, which is a fairly common posture that we're seeing these days. Then there's an excellent availability of resources for your country conditions. Okay, now we're going to move into TPS and removal proceedings. To start, what are removal proceedings? The very basic is that removal proceedings are an immigration court hearing where an immigration judge will determine whether a non-citizen is going to be removed from the United States. So removal proceedings are the proceedings that are taking place in immigration court. And removal proceedings begin with a notice to appear. The respondent, the non-citizens in immigration court are referred to as respondents. And they should be served with a notice to appear, letting them know that they are in fact in removal proceedings. And that notice to appear needs to be filed with the immigration court. And that's really what triggers the beginning of the removal proceedings. And the notice to appear needs to include the list of things that are here on this slide, including the nature of proceedings, the legal authority, the acts or conduct alleged. You can read through all of them and you'll get a copy of these slides. So I'm not going to spend time reading through all of them, but make sure you review your NTA very closely with your client and make sure that all of these things are included on the NTA, including, very importantly, the time and place of the next hearing and the consequences of failure to appear. If the time and place of the next hearing is blank, then that's not a proper NTA, and that can be contested in court. I'm going to briefly touch on the family group dedicated docket and then get into the rest of removal proceedings, because I know we have some pro bono volunteers on this training who are representing families who are part of the family group dedicated docket. So the dedicated docket was established this year in 11 cities in the United States, and the list of the cities are here on this slide. Families qualify or are placed into the dedicated docket if they were apprehended in between ports of entry after May 28th, 2021, and they were then placed in removal proceedings and enrolled in alternatives to detention. The goal, or the thing that makes these dedicated dockets stand apart, is that the goal is for the immigration judge to resolve the case and issue a decision within 300 days of that first initial master calendar hearing, which for those who practice immigration know that that's significantly faster than many non-detained cases in removal proceedings. The 300-day goal is not a requirement, but it is a goal, and different judges in the different jurisdictions are handling that goal differently, whether they're seeing that more as a guideline or being more really trying to hit that 300-day mark. It depends on the judge, but the rule and the guidance is that 300 days is not a requirement. It is a guideline for how these cases should be handled. So we'll touch on the dedicated dockets and how they play into these proceedings, but every removal proceeding starts with a master calendar hearing, no matter what kind of docket your client is on. If your client is in the removal proceedings, we're going to start with a master calendar hearing. A master calendar hearing is like a status conference, which can be a quick check-in with the court to kind of determine the status of the case and do some initial groundwork, but it's not a hearing where any of the merits of the case are going to be discussed or decided. At a master calendar hearing, requests for continuance can be made. So if it's your very first master calendar hearing, if you've just come onto the case, and let's say you haven't had a chance to review the NTA yet, or you just got it and you've reviewed it, but you haven't had a chance to discuss with your client yet, you can ask for a continuance for attorney preparation. And you should, if you haven't had a chance to review the NTA. We'll talk about that in just a second, but you should not enter any pleadings on it if you haven't had a chance to review it. So entering pleadings is the substance, really, the meat of what a master calendar hearing can be about. The judge will ask you to enter pleadings based on the NTA, which means you're either going to admit or deny factual allegations or contest or concede charges of removability. So what does that mean? I'm going to show you here a picture of a notice to appear. And we're going to circle back to this one in a few minutes, but for now, you can just notice it's redacted, but here at the top of the NTA, this is what it looks like. At the top, there are some allegations. The Department of Homeland Security alleges that you, and we've got 1, 2, 3, 4 factual allegations. So these are the factual allegations that you will be asked to either admit or deny at a master calendar hearing. And you need to review these very closely with your client. Do not admit to or deny, do not enter any pleadings on these allegations until you've talked to your client and have an understanding of what's true or not, because that has permanent consequences for your case. So you want to have a real understanding of what the facts are. So the first thing would be to admit or deny these factual allegations. And then you'll also be asked to contest or concede to this charge. In this example of an NTA, the charge of removability is here, saying that under section 212, that this is why this specific respondent is removable. And the NTA is alleging that, and you will be asked to either concede or contest to this charge of removability. So that's something that important that happens at a master calendar hearing. Now, like I said, there can be more than one master calendar hearing. So in your initial master calendar, if you're not ready to plead to what the NTA says, then you ask the judge for a continuance to have time to review that NTA, to discuss it with your client, and come back to plead at a later date. And you'll be set for, hopefully you should be set for a second master calendar hearing to return probably in fairly short order. And the judge might say, counsel, be prepared to plead at your next master calendar. But if you're not prepared to plead, then definitely ask for a continuance, and another master calendar should be set. If there are facts or issues in dispute, or if you're arguing that the court doesn't have jurisdiction because, for example, the notice to appear was not properly served on your client, or if you are contesting removability, then the immigration judge might do a few things. They might reset the master calendar hearing, asking DHS to present evidence contesting your claims. They might set another hearing to adjudicate those contested issues. They might say to you as respondent's counsel, okay, you need to file a motion to terminate, and I'm going to set a briefing schedule. If you're saying that that we don't have jurisdiction or there's no removability here, they might ask you to file a written motion, or the judge could terminate the case based on your arguments. So there's a couple different options there, and it depends on your judge and your specific facts how that will be handled. But if removability is conceded, if you go through your NTA and you say, yes, all of these facts are correct, and we concede to the charge of removability, or if DHS provides sufficient evidence to establish removability, and so that has been established, then the judge will sustain the charge of removability, and they'll ask you as respondent's counsel to identify the relief that you're seeking, and they'll set filing deadlines. So that relief, frequently in the context that we're talking about, would be for asylum or withholding or removal or relief under the Convention Against Torture. And they would set a filing deadline for when you need to file your initial application for asylum, or other types of relief that you might be seeking. They could set a filing schedule and then set an individual hearing date. An individual hearing is the date where your actual trial happens. So you might have a handful of master calendar hearings leading up to the individual hearing, which is when the judge is actually going to hear from your client, take testimony. You would take testimony. Your client would be subject to cross-examination. You could call witnesses, present evidence, have a closing argument, and then the decision on the merits would be decided at that time. So that's the overview of removal proceedings, which is important because now we're going to talk about how TPS impacts that. So the impact of TPS on defensive asylum, and defensive asylum means asylum that is an asylum application that's in removal proceedings. So you're in immigration court. That's what we refer to as defensive asylum. If your client applies for TPS and that TPS is granted, they're applying for TPS through USCIS, and if that request for TPS is granted, then there's an argument that they're no longer removable. The original notice to appear says that they're removable for whichever grounds, but if they now have status and a reason to stay in the United States, a legal ground to be in the United States, they're no longer removable. So at that point, there's a real question of, does this case even continue? And once the TPS is granted, it's possible that your case in removal proceedings is terminated or closed. So there's a couple options along the way. One would be that you could seek prosecutorial discretion, asking government attorney to dismiss or join a motion to dismiss because your client has a pending TPS. And each immigration judge might differ on when they say that it's appropriate to deem a respondent no longer removable. You might argue that just because your client is prima facie eligible for TPS and you've applied for TPS, that the case should be dismissed. But maybe they'll say, well, no, we have to wait until we have receipt of the TPS application being filed, or until the TPS is actually granted. And that's going to be a determination of each immigration judge. And I want to briefly touch, before I talk on different options of what you can do if your client is in removal proceedings, it's important to touch briefly on affirmative asylum, because these two options for seeking asylum could be potential options for your client. So affirmative asylum is for asylum seekers who are not in removal proceedings, that they've either never been issued a notice to appear or their case in immigration proceedings was closed, but they still want to seek asylum and think that they've got grounds for an asylum case. They will seek asylum before USCIS. And the process before USCIS is less adversarial. It's an interview with an asylum officer rather than a full-on merits hearing with cross-examination and a more contentious hearing. If asylum is denied at the asylum office and the applicant doesn't have any status, so let's say someone crossed the border, entered without inspection, was never issued an NTA, they decide to seek asylum before USCIS, and their asylum claim is denied, then they're going to be referred to the immigration court. They're going to be placed in removal proceedings. an NTA will be issued at that time, and they're going to be referred to immigration court, where they have the chance to again seek asylum. So they can kind of get a second chance to seek asylum. They're in removal proceedings, but they have a second chance to make their claim for asylum before an immigration judge and ask that judge to grant them asylum. So that's important background to know, again, for the TPS context, as we're evaluating the options for our clients who are in removal proceedings. If we're going to decide whether to dismiss removal proceedings, we need to know what other option for asylum would our client have if they're not in court. Then they could apply for affirmative asylum. Some things to be aware of. If your client, so as I just mentioned, if your client seeks asylum before USCIS, and they do not have TPS and they have no status for being here in the United States, if their asylum application is denied with their affirmative asylum, then they can be referred to the immigration judge for removal proceedings. But let's say you have sought TPS for your client, and your client now has lawful status and has TPS. If asylum is not granted, if their case is denied, then nothing happens. The case ends. They have status, so they're not going to be referred to removal proceedings. The potential problem there is that the status that they have is temporary through TPS. So later down the road, if TPS expires, if it's not renewed, then they could find themselves in immigration court proceedings later after that TPS has expired, and there's a possibility that conditions in their country could have improved at that point. So that's kind of the overview of what would happen if you're seeking affirmative asylum. Now we're going to bring it all together and explain kind of what these potential strategies are for your clients who are asylum seekers. So if you have a client who is in removal proceedings and is TPS eligible, one option would be to stay in removal proceedings, to continue to seek asylum in removal proceedings and not file for TPS. And if your asylum case is denied, to potentially seek a late initial filing for TPS. I'm going to talk about all of these in more detail in just a second, but right now I'm just outlining the options. So one option is just to do nothing with TPS and to stay in removal proceedings. A second option would be to file for TPS and seek prosecutorial discretion for administrative closure of your removal proceedings. And then if TPS expires, then you could seek to reopen, to recalendar your case in immigration court and move forward with the asylum case in immigration court. And a third option would be to file for TPS and seek prosecutorial discretion to dismiss the removal proceedings, to dismiss the NTA, get your client out of removal proceedings entirely, and then seek affirmative asylum through USCIS. So let's break each of these options down. And this is not an exhaustive list, but these are just some primary options that I want you to be aware of. And I'm going to break them down now. One overarching theme through this discussion is these strategies are very case-by-case specific. So I'll go through some of the pros and cons to each option, but really it's going to depend on the facts of your case, on who your immigration judge is and whether they tend to be more favorable or less favorable to asylum claims, your client's comfort level with participating in an adversarial hearing versus a less adversarial asylum interview, and your client's immigration goals, whether they are trying to bring family over, whether TPS is not something that they're as interested in. Obviously, there are more benefits to asylum, but having that whole conversation of what their ultimate immigration goals are is also important. So this is very client and case-by-case specific. With that caveat, jumping in. So the first option that I mentioned is to continue to seek asylum in removal proceedings and delay your filing for TPS. And then you could, if the initial designation period for TPS closes, initial registration period closes, but then is extended, you could file for late initial filing for TPS if your asylum claim is denied ultimately when you're in removal proceedings. This option is really best to be considered if you truly feel that you have a slam dunk asylum case, that you've got a really strong case, that you've got a favorable judge, that you've got a client that's comfortable testifying, that you've got strong evidence. If you really feel like I'm going to win on my asylum case and I want to move forward with it as quickly as possible and stay in these removal proceedings to get that done, then that's really one avenue where you'd want to consider this option. it's possible that your case could be resolved more quickly in immigration court. And that's especially true if your case is on the family group dedicated docket. Because remember, I said the goal for those cases is to adjudicate them within 300 days, which is fairly quick compared to other cases. So if you're on the dedicated docket and you think, this is definitely a case that we're going to get asylum, it could be a much faster path for your client than going through the other options I'll discuss. As I mentioned, you also want to consider your client's immigration goals and comfort level with immigration court. And also the timing of the case plays a factor. When you're coming onto the case, has the asylum application already been filed and is pending for a while? Your client already has employment authorization through the asylum case in immigration court. The one-year filing deadline, there's a one-year filing deadline for filing for asylum. It should be done within 1 year of arrival in the United States. Has that deadline already passed? And so you think it's better to stay in immigration court. So these are some of the factors to consider. If you decide, I don't want to seek TPS right now, because if TPS is granted, there's a chance that the judge will say, okay, what are we doing here? Why are we in court? Your client's not removable, and they'll dismiss the case. So if you're deciding, nope, we want to proceed on the merits, then this is one strategy to pursue. And your client may qualify for late initial filing of TPS. And to qualify for this, they need to be able to show that during the initial registration period, they had a pending application for asylum, and then they have to submit their filing either while the asylum application is still pending or within 60 days immediately after that application for asylum is denied. So as long as they're following those guidelines, then this could be something where they decide that they want to wait and pursue TPS depending on after the outcome of their asylum case in immigration court. Now, the other two options that I mentioned both involve prosecutorial discretion. One involves PD for administrative closure, and one is PD for dismissal. So I'm going to touch on prosecutorial discretion briefly to let you know what that is, and then go into the specifics of these two options. There are entire trainings out there on prosecutorial discretion, and I'm going to move fast through this. If you need more trainings, again, reach out to me and I can refer you to some great resources. But basically, prosecutorial discretion is the prosecuting agency's prerogative to decide how they want to enforce a case. So PD can decide, prosecutorial discretion is not a type of relief itself necessarily, it's the mechanism through which relief is requested or agreed upon with the government attorney. Through prosecutorial discretion, you can seek dismissal, administrative closure, continuances, you can request to narrow the issues, or even have an agreement that relief should be granted. So I like to think of PD really as it's kind of a more formal meet and confer with government attorneys, but there's a specific process through which it must be done. There is an important memo on PD that came out earlier this year, the Travinia memo, that specifically says that if a non-citizen has an avenue available to them where they can get temporary or permanent relief, it's generally appropriate to move to dismiss these proceedings. And the memo specifically says that if someone appears to be prima facie eligible to register for TPS, then prosecutorial discretion to dismiss that case may be appropriate. So that's important to keep in mind that there is clear guidance out there saying that PD for dismissal is appropriate if someone's eligible for TPS. What is dismissal? Dismissal is really a cessation of the proceedings. It's not actually a form of relief, it's just the discontinuation of the removal proceedings. So the charges in the NTA would be dismissed and your client would no longer be in removal proceedings. This really makes the most sense if there's an alternate form of relief available, such as TPS, which is available to your client so that they have another avenue of relief that they're pursuing. Administrative closure, on the other hand, is kind of hitting the pause button on your client's case in immigration court. The case would be removed from the active docket and placed into a dormant docket. So no further hearing dates are going to be scheduled, but your client is still in removal proceedings. And either party can file to recalendar the hearing at any time. One thing to note about administrative closure is if your client has work authorization based on an application pending before the court, if that case is paused and administratively closed, they still have their work authorization. It still can be renewed. as opposed to dismissal. If the case is dismissed entirely, if they had work authorization, then that work authorization is also dismissed. So that's just one major difference between the two that is should be considered. So now back to our asylum seeker strategy. One strategy would be to file for TPS and then seek PD to administratively close the removal proceedings. And then they can continue asylum and removal proceedings later if you want to recalendar the case after TPS expires. The main reason why you might want to consider this option is for the employment authorization document, like I mentioned. So if your client has already been, let's say asylum application has been filed, EAD was granted, it's been pending before the immigration court for quite some time, then they might decide that what you want to do is hit pause on it, file for TPS, get the TPS benefits, and keep the employment authorization benefits through the pending asylum case, and then reopen the case if TPS expires in the future. The real kind of downside to this is that country conditions can change. A long time can pass before you're back in court. Things can change. You can lose contact with your client. There really can be a lot of different things that go on. And also you should know that any party, including the government, can move to recalendar the case at any time. So you're always, just that could happen at any moment. And then the third strategy that I wanted to review with you is the option to file for TPS and seek PD to dismiss the removal proceedings. And then you can pursue an asylum claim through affirmative asylum through USCIS. So the benefit to this is that you're getting your client out of removal proceedings. And that can really be a big sigh of relief to someone who's in removal proceedings, is that you're just dismissing that case entirely. And then if they want to seek asylum, they can do so through USCIS, which is a less adversarial process. And it can be a more, just a emotionally, mentally easier way to go about the process for a lot of clients. There can be a long backlog before USCIS. It is possible that the asylum case wouldn't be heard for years. And the other thing to keep in mind with this is that if the applicant has TPS and their case is denied before the asylum office, then they don't get referred to the immigration judge for that so-called second bite at the apple. The case is just closed at that point, and they don't have, all they would have is TPS, and if TPS expires, then they don't have any other relief available to them. So with all of these strategies, there's some pros and cons, but it's a good conversation to have with your client about what might be the best path for them. If you do decide to seek prosecutorial discretion for admin closure or dismissal, then the general structure is to send a letter. It gets emailed to your local OPLA office. It needs to include the type of relief you're requesting, the reason that your client merits PD, along with some supporting evidence. So each jurisdiction is really different with PD, and you should refer to your local guidance. But if PD is requested, then you need to provide their proof of their receipt or grant of TPS if you've got it. And depending on the jurisdiction, the jurisdiction might require that you submit an FBI fingerprint check. So you really need to have a candid conversation with your client about their past criminal history, if they have any, and determine whether it makes sense to seek PD based on that history, or if it would be better to not, because there's certain things that you wouldn't necessarily want to disclose in a PD request. So conversations to have with your client. Like I said, there's excellent trainings on PD out there. So if you need more just on this process, please reach out to me. We also have developed some practice guides that are really helpful, so we can give you more information on PD specifically. And last thing I wanted to touch on quickly is just the mechanics of the court procedure. So this is an example. Let's say you are seeking TPS and prosecutorial discretion to dismiss your client from removal proceedings. And I'm specifically giving this example in the context of a family group dedicated docket case. So my recommendation would be to file your TPS application as soon as possible. You want to get that in as quickly as possible so that the relief can hopefully you can get the relief sooner rather than later. And similarly, you want to submit your request for PD as soon as possible so that the government attorney has advance notice of what you're doing. There's a preference that it's submitted at least 3 weeks before a merits hearing, and you want to just do so as soon as possible. Then at your initial master calendar hearing, if you know your client has TPS and that you're going to be seeking dismissal, If it's possible, you want to avoid pleading to any of the facts and charges in the NTA. If you're going to be dismissing anyway, the less record of admissions you have, the better, just to cover those bases just in case down the road. If it's your first MCH, you can ask for a continuance to have more time to prepare or review the NTA with your client, if that's reasonable, based on the amount of time you've had with your client. Or you can tell the judge that your client is prima facie eligible for TPS, that you filed for TPS, and that you're seeking PD to dismiss, that you've already done so, or that you will do so. And you can ask the judge that you don't have to plead. But if the judge does make you plead, which sometimes they do, again, it depends on the judge, and some might say, okay, great, counsel, you've applied for TPS, but still we're going to move forward with this case, and we're going to move forward, and I'm still going to ask you to plead. Then you can admit to facts, or if they're true, on the NTA, but you should contest removability at this juncture, because your client is prima facie eligible for TPS. They have a legal ground to be in the United States, so we can contest removability. So what do I mean by that? Just looking quickly to the facts and removability. This is the NTA I showed you previously with a few sections highlighted. This one's for a child who's a child of Haitian parents, but she was born in Chile. So I have this highlighted here because this would be a fact worth contesting or denying if you're pleading on this NTA. It says you're a native of Chile and citizen of Chile. We would want to make sure that on the record, we're making clear that this child is a citizen of Haiti as well, because we don't want a record where we're just admitting that she's Chilean and not have a record showing that she's a Haitian citizen for purposes of our TPS. So that would be one point to make. And then on whether we're contesting or conceding to removability here, this says that our client is removable. We would contest removability because we're saying our client is eligible for TPS, and because of that, they are not removable. They have a legal ground to be in the United States. And a final point, if a removal order has been entered against your client, that's not necessarily a bar to TPS. So if you are at that stage, you can still apply for TPS. And if your client is detained, they can also still apply for TPS. And final note here is just to evaluate the strength of your asylum claim. That will help inform all of the decisions you're making on which decision is best for your client. And specifically for Haitian clients, it might take a few conversations before they really can open up to you or share with you about why they might have an asylum claim. And so it might require multiple conversations. Make sure you have an interpreter so you can understand your client, and try to review some country conditions so you can understand the background of the country your client is from, which might also help you understand when they're saying something that happened to them. It might help you understand that there is an asylum claim there. I want to open it up to questions now. We only have a few minutes left. Let's see. I see that Adonia has been answering some questions throughout, but are there, let's see, I'm just scrolling here.
So we had a great question that I answered in the Q&A about detention and serving as residents. I really advise folks to take a look at the code, the federal regulations, which addresses the requirements for residents. It really doesn't, it's regardless of the individual's intent. So I think there's a lot of arguments that if one is in detention, that you are a resident of that facility. So there's a lot of great language from the regulations. So I would direct you to that. Another question that we got was a little bit outside of this presentation. It was about family-based adjustment for individuals with TPS and removal orders. This is an issue that's actually being litigated in South Florida and some other places. There was recently a policy change. I can provide some resources on that to Stephanie if you want to reach out to her for more information. We provided her email in the chat, and I can give you some more specifics to that question. And looks like we had another question that just came in right now about a client who was in removal proceedings and their TPS application has been filed but is still pending. Would it make sense to seek a continuance until TPS is granted? They have a good asylum case, but not quite a slam dunk. So the question is really like, wait or move forward. Steph, I think you kind of talked a little bit about this, but do we want to discuss it one more time?
Yeah, I think that's really, again, that comes down to this case-by-case decision based on what you know about your client's facts and also the judge that you have in your case. But generally speaking, the options here would be that you could seek some continuances and wait until the TPS is granted and then decide what to do. Or you could decide that you want to move forward with your asylum case and do that before your removal proceedings. But it's going to be one of those things that, again, is just a case by case, really fact specific evaluation for you to make. So it's hard for me to give exact advice for your situation.
Yeah, and a second question within that question is about whether having TPS would improve one's chances of a favorable discretion from the judge or the ICE attorney. I mean, I think, temporary protected status is a reflection of the country conditions, that there's either civil strife or natural disaster, which could definitely play into an asylum case, citing that the country was designated TPS, but it doesn't necessarily apply to the specific elements of your client's eligibility for asylum. I don't think necessarily having TPS would change that calculus necessarily in determining eligibility for asylum. It is a positive factor when asking for a continuance or dismissal, however. So it wouldn't necessarily change, your asylum case and the favorable discretion exercised by a judge, but it would play into a continuance. So we hope that answered your question.
And I just want to say before we end here that there are some opportunities if you're not already working on a case and you want to volunteer on a case that deals with these issues. There are a few volunteer opportunities through the ABA Commission on Immigration. You can scan this QR code on your screen right now, and that'll send you to our volunteer sign up. And I believe that Bridget is going to enter the volunteer sign up form in the chat along with my email. But we have opportunities to help with TPS applications through a legal clinic. To do some direct representation with TPS applicants who have more complicated issues like firm resettlement or dual nationality and need representation throughout their TPS claim because they're going to have some firm resettlement questions. And we also have opportunities to represent clients in these family group dedicated dockets that are on this more expedited docket, and many of them are TPS eligible, along with being in removal proceedings. And so if you're interested in any of these opportunities in kind of practicing your skills and representing a client in this area, please don't hesitate to submit our volunteer interest form, and we can give you more information about how to volunteer and how to use some of these skills in practice. All right, and with that, I think we'll close today's presentation. If you have any further questions or want more resources, please feel free to email me and reach out. And thank you everyone for joining us today for this training. Take care.